Nebraska Extension Ag and Water Law Specialist Dave Aiken says a 2013 tax law change could simplify farm and ranch estate planning. The portability rule could help surviving heirs pay less taxes on inherited wealth. Dave joined us Tuesday to explain how the rule could make planning easier.
This is a recent change in the law that makes it easier for married couples to basically exempt twice as much property from federal estate tax as they could before.
Explain to me how it works.
Well, it's complicated, so we'll kind of have to, take it historically. But basically, all estates have an exempt amount of $5.45 million each year. And what that means is that basically 99% of all estates in any given year are not subject to any federal estate tax.
So this portability rule would be most important then for those estates over that amount.
That's right. And before the portability rule was available, these families would have to go and get some legal work done to try to deal with their state tax problem ahead of time.
Yeah, describe to me what they would have done here before the portability rule existed.
Well, historically, the way it would be is that, when one parent would die, they would leave their share of the farm to the surviving spouse, and then it would go to the kids. And so the second parent to die, there would only be the one exempt amount available to the kids. And so they could end up with a federal estate tax bill if it was a large estate.
How would the estate planners get around that then?
Well, basically what they would do is they'd have each parent would gift their half to the kids instead of to each other. And so if dad dies first, his share of the farm would go into trust for the kids, but mom would get the income, and then when mom died, the trust would be dissolved and the kids would have it all. And the kids would have the benefit of two exempt amounts instead of just the one. The
portability rule then allows you to take both the mom and the dad exemption.
That's right, without having to get an estate plan with the lawyer first to set it up that way.
All right, so give me an example of how this would work.
Well, let's just take it from the beginning, with no portability and no estate planning. So dad dies, his share of the farm goes to mom. Mom dies, she leaves an $8 million farm to the kids. Her exempt amount is $5 million, so the kids have a $3 million estate they have to pay taxes on, and it ends up being about $1.1 million, so it's not chump change.
So what would happen if they had estate planning but still before portability?
Okay, dad dies, his share would go to the kids in the trust, but it would be taxed, so his $4 million share would the $5 million would take care of that and have some left over, and so kids get that much tax-free. The same thing happens when mom dies, so they inherit, the $8 million farm with no federal estate taxes.
Now the final example, which would be with portability.
Well, this way, they don't have to have the trust, so dad dies, the farm goes to mom. She has to file an estate tax return, and that's kind of the little wrinkle, but it's not that hard. It's not that hard to do. You just have to do it. And then, when she dies, the farm goes to the kids, but they get the full $5 million from dad and the full $5 million from mom, so it's an $8 million farm, so the kids don't owe anything.
In that regard, then, this would be a good thing.
Yes, for these families with the large estates, the portability rule is really good, but they still need to adopt a estate plan.
Right, that's the question then. Do you still need to?
That's right, because there needs to be a transition from mom and dad to the kids. They need to decide, who's the on-farm heir and the off-farm heir, what's the split going to be, some end-of-life issues that everybody needs to deal with. It's really important to have those things addressed. And if you don't, you could end up owing no federal estate tax, but the farm goes on the auction block because the kid can't decide what to do.